Akeredolu faults APC zoning arrangements for NAS leadership as skewed injustice. Obi Labour Party asks tribunal to televise proceedings. Court bars NBC from imposing fines on broadcast stations. And outside Nigeria, mass protests planned in Senegal over poll halt. And Kenyatta's woes deepen as Kanini Kega cancels Jubilee Party National Delegates Convention. The Presidential Election Petition Tribunal has begun sitting to hear challenges against the victory of Bola Tinubu of the All Progressives Party as Nigeria's next president. While it's just been 3 days since the sitting started, there are some interesting developments that have come into play. With an adjournment on one aspect till May 17th, let's look at all the happenings as Nigerians await the decision of the tribunal in the weeks or days to come. This is Politics HQ. I'm Tolulokwe Adelere Balogun. Welcome. The Presidential Election Petition Tribunal sitting in Abuja has deferred further proceedings on the petition of Peter Obi and the Labour Party that was filed to challenge the outcome of the 2023 presidential election to May 17th. The adjournment today came after all the parties to the matter, that is the Independent National Electoral Commission, the President-elect Bola Tinubu, Vice President-elect Kashim Shettima, the All Progressives Congress, and Obi and the Labour Party met on the matter and told the courts that they had agreed to ask for an adjournment to enable them to file and exchange necessary legal documents. This adjournment comes just 3 days after the tribunal, in most effects, kicked off. Now, the court has asked that the parties identify core issues to be determined in the petition. Today also saw the Action People's Party withdraw its case against the APC and INEC. My guests tonight are Achike Chude, public affairs analyst, and Paul Mugweba, legal practitioner. They both join me on Politics HQ to get into the issues around the tribunal's sitting. Gentlemen, welcome to Politics HQ. Thank you so much for joining me.
Thank you for having me.
Mr. Ngbeoba, I would like to start with you, and that starts with us looking specifically at the LP candidate Peter Obi in his petition and the prayers he put before the court. Now, he wants this tribunal to declare that Tinubu was not duly elected by the majority of lawful votes cast at the election. He has hinged his petition on 3 grounds. 1, that at the time of the election, Tinubu was not qualified to contest. 2, that at the time Tinubu's running mate, Senator Kashim Shettima, became the vice presidential candidate, he was actually still the nominated candidate of the APC for the Borno Central senatorial election. And then 3, Obi and the LP have challenged Tinubu's eligibility to contest the presidential election, alleging that he was previously fined $460,000 by the United States District Court, Northern District of Illinois, for an offense involving dishonesty and drug trafficking. So while the case is now before the tribunal and there are limitations to what we can discuss on this, do we see a petition that, in your estimation, has merit in terms of raising serious questions about Tinubu's victory?
Yes. So, of course, every petitioner who goes to court believes that there are things that are wrong with an election, portion to which he feels that when he goes to court, he will be able to get the necessary reliefs as provided by law. Now, usually what happens, as you have rightly pointed out, is the fact that the petitioners, that is in this particular instance, Mr. Peter Obi and the Labour Party, feel that the election of 25th February 2023 was not conducted in accordance with due process of law. And right, that is their contention, right? So, and good thing, the law has made it available for anybody who feels aggrieved by the outcome of an election to challenge that election. And that is what the Labour Party and their candidate, Mr. Peter Obi, have done by taking the necessary steps as provided by law to file this petition. Now, having filed this petition, the petitioner will be subjected to the necessary legal process, which has now kickstarted by the commencement of the pre-hearing session. Now, the pre-hearing session is provided by paragraph 18 of the first schedule of the Electoral Act. It is during this course of pre-hearing that parties would identify, together with the court, the modalities that the course of the trial itself would take. Now, it is at the point of trial that the petitioners will then have to lead evidence to prove their case. When they have led evidence to prove their case, it then behoves on the respondents to also lead evidence in disproof of the petitioner's case, at the end of which the court will then be left with the opportunity to decide based on the evidence that has been led by both parties as to the merits of the petition or otherwise. And then again, whoever is dissatisfied or aggrieved by that petition of the court, in this instance, Court of Appeal, the court of first instance, is again given the opportunity by law to appeal against that decision to the Supreme Court, where the at the end of the day, the Supreme Court will then give the final decision point. Now, it is important to state that it's not just about stating that maybe a particular person was not qualified, or that there was an issue of double nomination, or that the person who was elected was not really elected by a majority of both votes cast, right? So at the end of the day, it all boils down to how much evidence that the petitioner can produce, how much evidence he can lead to establish these allegations.
Okay.
So that is, yes, how it works.
Okay, so let me bring Mr. Trude into this, because the court has asked that the parties in this matter identify the core issues to be determined by the court before the tribunal resumes on May 17th. As we look at how things have shaped up in the past few days, what are the questions we expect a judgment in this case to answer, Mr. Trude? Because what is before the tribunal in terms of the prayers of the remaining petitioners, we'll also talk about the fact that two petitioners have dropped out in the past few days. There's also questions that even just voters here in Nigeria have. So what questions do we expect a judgment in this case to answer?
So obviously Nigerians were very much traumatized by the outcome of that election. And a lot of Nigerians have not exactly recovered. They were affected psychologically. Ordinary Nigerians who for the first time had that newfound belief that perhaps this time around we're going to get it right. Don't forget that coming into this election, a lot of people had said that the elections don't count in Nigeria. But there are a few successes, under INEC, the election in Anambra to Kashim State, APC State. So that gives people a lot of hope. And so some of us in civil society were able to carry this hope into the public space, including the media. The media did a lot of work trying to convince Nigerians, especially the young ones, that this election is going to be different because Rivers is going to be the game changer. And a lot of them were patriotic. And even for those who derided them and accused them of just being social media warriors, that they were not capable of coming out, and meeting them in the public, in the polling units, to cast their vote. And it was a challenge that the youth took up gladly and came out in their numbers and were very happy and well mobilized, and enthusiastic about the process, and actually got involved in that process and cast their votes on the 25th of February. By early March, when we had the second round of election, or the middle of March, it was a completely different ballgame. Though there were problems with the 25th, especially with regards to the inability of the INEC to transmit the result of the presidential election, which was a major disappointment, contrary to their laws. That was that March, the election, the governorship and the State House of Assembly election was a completely different ballgame. Violence took over, manipulation, rigging, cutting of ballot boxes, in many parts of the country. And so the face of that election changed completely. So Nigerians are still smarting from that. Of course, you saw indications that the young people being disappointed with the process some of them decided to do away with their PVCs, which was the wrongest thing to do anyway. And so Nigerians will want justice, and I think that this is what Nigerians are looking for. And some of them want to hope that they can have that justice at this tribunal. And obviously, a lot of them, like I said, are absolutely disappointed. You know that after the election, the next thing the politicians, the old guys, who are used to this kind of malfeasance during the election, now came up with a new narrative. It is time to move on. The election is over. Let's move on. But you can't move on. Where is the place of justice? And that's what people are asking for. And so the issue is go to court, which has always been the game plan of the politicians. Some of these discredited, dubious politicians, they manipulate the process, and then the next thing is you go to court. And then hoping that, and that's where the issue is. I know that the legal person there has talked about the issue of being decided on the basis of evidence. But it's not about evidence as far as Nigerians are concerned. It's about integrity. It's about the moral disposition of the judges to want to do justice. If you remember the great Fela Anikulapo, in his days had a lot of running battles with the judiciary. He said that anything can happen in the judiciary. They have the capacity to turn blue into red, green into yellow, black into white. And that was even a time when the Nigerian judiciary had fairly reputable judicial, officers. Somebody like, the late, philosopher, George Chukwudifo Ilori, and so many other Nnamani, and so many others that had a lot of, reputation, who could stare the military in the face and say, look, this is against the rule of law, and rule against the military dictatorship. But this is completely different. So when you talk about evidence and so on, it is good. That's what lawyers are supposed to do, provide evidence, and on the strength of the evidence, the judges, take a position. But the judiciary has been eroded. The presidential judiciary in this country has been eroded over a long period of time. That
Mr.
some
Chude,
of them are just people feel that they have. Yeah.
Okay, we'll get into that because of the calls for the televised hearings and where those are coming from, possibly from this same area you're taking us to. But I want to go back to Mr. Ingbe. When you look at this conversation, particularly for the merits of the case and even the core issues to be determined, I'd like to get your thoughts on that. So when you look at the case before the tribunal, you look at the petitions that now remain before the tribunal, what do you think is really at the core of this case, or the core of Peter Obi's case and possibly Atiku's case, Atiku Abubakar of the PDP? Because there are a few slight differences in what they have both put forth as their prayers, but we know what they both want in the end.
Right. So taking this case and the Labour Party first, part of their contentions are that the president-elect did not have the majority of lawful votes cast, and also that the vice president candidate also had a double issue of double nomination, right? They also talked about the fact that INEC did not comply with its guidelines, particularly with respect to the issue of upload of results on the IREF. Now, on the part of PDP and Atiku Abubakar, they also made some similar contentions with what the Labour Party also said. Now, another angle which the PDP also brought into the mix is the issue of margin of lead. Now, if you look at the margin of lead between the president-elect and Atiku Abubakar, you see that there was just about 1.8 million or so. Now, the PDP, part of their contention is that if you look at areas where there were issues of maybe cancellation or non-holding of election, that the number of voters in those areas outweigh the number of margin of lead between the winner of the election and President Kashim Shettima, that is PDP. So part of their contention is that based on that, the INEC ought not have declared the president-elect as winner of the election. So that area is one very important area that I think I'd like to see, and a lot of Nigerians would also like to see how the Court of Appeal and ultimately the Supreme Court resolve that issue, because that issue of margin of appeal is one issue that a lot of people are actually not even talking about, but it's a very potent issue that can swing the decision one way or another.
Okay, so Mr. Chude, let me bring you back to this conversation, because it's not just the Labour Party and Peter Obi that took INEC and the APC to court. So we also have, of course, the People's Democratic Party, which is in the mix. And before today, there was the Action People's Party as well. So after the APP announced that it was withdrawing its petition, the tribunal dismissed it. Then the Action Alliance also withdrew its petition against Tinubu, the APC and INEC on Monday. When we come back to the APP, interestingly enough, before withdrawing its petition, the lawyer had said instead of proceeding to the main hearing, parties could choose to settle disputes amicably. He said that the respondents, meaning Tinubu, the APC and INEC, should concede to the claims that the APP was making, considering the weight of the claims against them. But these two parties have now withdrawn their petitions at the tribunal. What are we to make of these petitioners dropping out, especially as sort of the landscape around the tribunal shapes up in the pre-hearing stage, and we finally get to the nitty-gritty, hopefully, in the coming week?
When you are asking this question and making reference to this political parties, perhaps a lot of us do not know that many of the political parties at play in the country currently are being financed by some of the major political parties. And so what happens, before an election is that some of these parties, they are being funded by the main political parties. So some of these parties come together, they could be 10, they could be 15, then they come together and they will tell you that they have endorsed a particular candidate. And all of this is about the optics. So that's what it's all about. For people to give people the impression that, yes, that these particular heavyweights or specific, heavyweights, have a lot of support. Even opposition parties are also endorsing them. So for all you know, I was very suspicious of even a claim by any other political party other than the PDP and the Labour Party that had made significant ground in this election. And don't forget that if you count Abuja as a state, that both the PDP, APC, and I think the Labour Party all scored about 12 states, all had about 12 states. Maybe one of them won or maybe 13 states or so. So it is not surprising to me. And like I said, I was suspicious of any other party that did not make any headway in this particular election going to court and to go against the APC to challenge the win by the APC and the presidential election. And then, so I'm not surprised when the verge of the hearing of this matter in the court, that some of them, have actually told that. I expected, once I heard that some of these smaller parties, many of them relatively unknown, and who did not make any significant, even non-marginal, positive effect in the election, had actually gone to court to challenge the APC victory. I suspected that this was going to happen, that they would pull out of this process of challenging the APC, because, like I said, a lot of them are there, have this mercenary, to a very large extent, and the leadership of these parties are mercenary. And that's my own take, because I have seen some of them, closely, and I've seen what they do. So I'm not surprised that they pulled out.
So staying with you, Mr. Chude, do you expect to see the Allied People's Movement, which also has, they're still in this mix as well, and the tribunal is meant to hear their pre-hearing tomorrow. Do you anticipate in the coming days, or even possibly tomorrow, we might hear them also drop out of this situation?
It is not impossible. It's what I expect. Because the issue really is, what are they claiming? What are they looking for? What are they challenging at the victory of the APC, and what is the purpose of that challenge? Where did they score electoral victories that put them in a position to say, yes, we can successfully challenge this presidential election at the tribunal, And with the hope that when they lose out, if the court hears our prayers, then we can be declared winner of the presidential election. What exactly is their case? And that's the issue. I do not think that they have much at stake, except to give the impression that maybe they just go in there and then at the end of the day, they say, look, we accept the fact that the APC presidential candidate and his vice declared that INEC have won that particular election. So I think that this is just a ruse, it's just a distraction. Personally, that's my feeling, because I've seen them close up and I know, what some of them do.
Okay, so Mr. Ngweba, let me come back to you with the APM. So the Allied People's Movement, their petition is actually asking that Tinubu's victory be nullified on account of his non-qualification as a candidate of the APC. Now, this party doesn't want their candidate declared winner. It wants the candidate of the PDP, that's Atiku Abubakar, to be declared winner of the election. Tomorrow, we're expecting that we'll be hearing some pre-hearing involving this party and, of course, other parties at the tribunal. But what do you think the sitting tomorrow is going to look like on Thursday? What should we expect? What should Nigerians expect when it comes to this additional petition that's before the tribunal?
Right. It's quite interesting that a petitioner would institute a petition and then request the court to grant reliefs that will not give benefits to him, but to another person. So I would like to see how that works. But from my knowledge of the law, you cannot institute an action and then ask the court to grant relief to another person, not you. So we'll see how it goes.
Mm-hmm. So it might give some credence to what Mr. Chude is saying. But he said something else, Abuja as a state. And that's been a major part of the conversation around the challenging of the victory of Tinubu as president-elect of Nigeria. Is it this tribunal, do you think that their judgment in this case will finally put sort of an end to that conversation around whether Abuja should be perceived as a state, or it's a situation of or will we end up seeing the Supreme Court finally put a definitive end to this aspect of the conversation?
That this decision would put to finality the controversy surrounding the interpretation of that particular section as to whether the and there means or should be given a conjunctive interpretation, by which sense would mean that Abuja will be taken as one of the states, or that it should be given a disjunctive interpretation, which would then mean that you would have to look at Abuja separately. Now, there are different schools of thought. One of the schools of thought tries to explain it in this, simple way, to say the idea of that provision is likened to where a person is intending to enter into maybe a university or a higher institution, and they say before you can qualify to study a particular course, you must have 5 credits, right? And a particular course, right? So that even if you have 5 credits and do not pass a particular course, it means that you are not eligible to get that admission, right? The other school of thought is of the opinion that if you give that kind of interpretation, like to then elevate Abuja to a status of a determining state, so to speak, as to who can become the president. But what it then means is that the entirety of the country will be held hostage by Abuja votes. So what it means is, even if the president scores the majority of lawful votes cast across 24 states, or 25 states, that's the third majority of the states, but does not win or score 25% in Abuja, it means that the person cannot be sworn in. So what that means is that a winner of an election with in such a scenario with maybe a high margin and scores the required number of percentage of votes, but does not win or score 25% in Abuja, will be held hostage by the Abuja votes. So then again, it's begin to look at it like, can that be the correct interpretation, or can that be the intent of the drafters of the Constitution? So it's another interesting aspect of the petition that the court would have to determine and give the decision, which would then lead to rest this controversy arising from that provision of the Constitution.
All right, and it seems that one we will continue to have to wait on. Gentlemen, we're going to take a quick time out, but when we come back, let's get into the conversation, of course, that revolves around televising the proceedings of this tribunal, as well as the recent judgment in Osun State. Could that be showing us a sign of things to come? Politics HQ will continue after this. Tonight on Politics HQ, we're looking at the proceedings of the Presidential Election Petition Tribunal that started sitting on Monday with pre-trial or pre-hearing sessions, and a number of things have come out. 2 petitioners have dropped their petitions against the election and the victory of President-elect Bola Tinubu of the APC. But now let's move on to something else that has come up in the lead up to this and is now also being a larger part of the conversation. Now, the People's Democratic Party's presidential candidates Atiku Abubakar and the Labour Party's Peter Obi have both asked that the tribunal's proceedings be televised. With the criticisms of the conduct of the polls, Nigerians really want to see for themselves how the tribunal's judges will scrutinize and process the cases that come before them. My guests tonight, Achike Chude, public affairs analyst, and Paul Ngbeoba, legal practitioner. So, Mr. Chude, I'll come back to you with this because in one of my earlier questions, you had gotten into this conversation around the potential of Nigeria's judiciary being compromised and a lack of trust. So let's look at this with the calls for the televising of the tribunal's proceedings. Is this about a lack of confidence in the judiciary, or is it really just about the level of interest we've seen in the 2023 elections?
Indulge me a bit. I just want to speak a little bit about Abuja and the status of Abuja and the 55% before getting into your, to this question. Look, there is, the provision made the 25% to be scored specifically in Abuja was not, no other state was given that prerogative. Not Sokoto State, not Anambra State, not Lagos State, any other state. It is the only part of the country that is supposed to be, or that is described as the center of unity. I know it's just like, and then when people are now saying, well, is it that you can, one part of this country can hold the rest of the country hostage? Is that what the framers of the Constitution meant? Look, ultimately, at the end of the day, it is going to be decided one way or the other. But don't forget, for instance, when you are talking about the presidential election in America, you are talking about the Electoral College. The question has been asked, how come that the majority, sometimes, depending on how an election went in the United States, that the candidate with the least number of votes actually becomes the president of the United States? And that's why people are talking about abrogating the Electoral College. But they are not saying that that law itself is illegitimate. It is wrong. There is only, the president of this country is supposed to be the governor of, the Federal Capital Territory. And the National Assembly legislates for the Federal Capital Territory, and so that tells you that there is a very special status, that Abuja has. Now, what you do ultimately at the end of the day is, if there is a problem with the Constitution, you subject it to amendment, and that's why you have the first, second, third amendments like you have in the United States and all that. But to say that you're just going to throw it away completely because Abuja is going to hold the rest of the country, hostage, I do not think, well, like I said, what exactly did the framers mean? It is the center of unity. So whoever it is that is going to be in charge of the center of unity must have some level of acceptability in that part of the country. Now to go back to what you are saying about them, televising, the whole, process in the courts. You are absolutely right in terms of the questions you are asking. I think it is as a result of the lack of trust, of the judiciary, and over time, the judiciary, has been undermined internally. And so you have all kinds of lawyers, who have been reported to be the ones instigating some of the rot and the malfeasance that have been going on in the judiciary. And a lot of judges on whose behalf they conduct these nefarious activities. And so you have a judiciary that no longer has the trust and the respect, of Nigerians. We have seen them with all manners of cases over the years. with the, where you have even with courts of coordinate jurisdiction, completely abandoning the principle of stare decisis, which says that once a court of a particular jurisdiction has made a ruling, that courts of coordinate jurisdiction, also have to abide, by those rulings. So the Nigerians no longer have any modicum of respect for judges and even for lawyers, who they also hold responsible for some of the rot in the judiciary. And so this clamor, for us to have this hearing done in the public space, of course, it is not unconstitutional. And I think it is a legitimate demand. And so if the judge, somebody spoke on behalf of the Election Petition Tribunal and did promise that they were going to ensure justice. But we have to see it. It's not just on the basis of the assurances that you are giving, Nigerians, because Nigerians do not have that trust anymore, absolutely. And so it is better that it is done that way. And I'll just end up by saying, by talking about Obasanjo's third term. Remember when Obasanjo wanted to go to third term and there was so much controversy, so much, suspicion over the whole process. The chief, the speaker, the president of the Senate, I think it was Nnamani, I think he was one that said, look, I know my father's name. I don't know if you know your father's name, but this is time for everybody to answer their father's name. And because that particular sitting of the National Assembly was done in the public space, a lot of the senators who were alleged to have collected money, 55 billion naira for each senator then, that was in the open, it was everywhere in the media. A lot of them lacked the guts to come out publicly to say to Nigerians that we're in support of a third term for President Olusegun Obasanjo. And as a result of that openness and the transparency surrounding that sitting, he died a natural death. This is what we hope ultimately at the end of the day, that we have this sitting of the court for such a momentous period in the life of this country, for such an election that was conducted in an atmosphere of serious, great controversy. Yeah, it is, I think, in everybody's, especially in the interest of the judiciary, to show transparency by allowing this process to be beamed live to the homes of Nigerians.
All right. Mr. Mboba, I'd like to get your thoughts on this, because the recommendation for televising the tribunal sittings is said to also be about restoring unity, dousing the tension in Nigeria, and even legitimizing the incoming government. And I found that to be quite interesting from those who are making that argument that the tribunal's public televised proceedings would be what would legitimize the victory of Bola Tinubu if the judges in the tribunal uphold his victory. But do you really think that's something that televising the tribunal can do for us at this point in time? And I'd even need to ask, how would we go about this? Is it a request from the media? Is it just simply at the favor of the judges of the tribunal to make this decision? We're already in the pre-hearing stages. We're seeing some things inside. How do we know, or when do we know, if the tribunal will agree to televise its proceedings?
Right. So the issue of having the proceedings televised for Nigerians to witness or watch from wherever they are, for me, is neither here nor there. Now, I understand that the contention of the petitioners would be to the effect that the Constitution provides, if you look at Section 36, subsection 1, and also subsection 3. Now, Section 36 guarantees the right to fair hearing of every person in the determination of his rights and obligation by a court constituted in a manner that secures its impartiality, right? Now, if you go further down to subsection 3, it then talks about that in the determination of that civil right and obligation of the citizen, that the courts shall be considered in such a way that it shall be open to the public. Now, the question then becomes, what is the definition of the court being open to the public? My understanding, the court being open to the public is the fact that any member of the public can have access. If you look at even from the footage that you're showing, you see that it's not only lawyers that are there, there are so many other persons of different interests and walks of life that are there. So that is what my understanding of having access to the court means. But there is nothing wrong, again, if the court is minded to agree with the petitioners that having access to having access by the public to court would also include having a televised proceeding where Nigerians can tune in from wherever they are. So that's also another angle to look at it. So, but really, I'm not sure it would affect the substance of the proceeding, whether it is something that Nigerians would have to tune in from wherever they are, or whether Nigerians would necessarily have to visit the court to physically enter there. So I think that it would affect the substance of the case.
So let me stay with you, because by the calendar dates, we're 19 days away from swearing in. And it seems a bit unlikely that the tribunal will have reached its decision by that time. Well, we could cross our fingers and hope. But is it time that we also look at the Constitution, the Electoral Acts, to ensure that elections and the petitions that spring up from these elections are wrapped up before a winner is sworn in? That's also been a part of the conversation that's been bubbling to the surface. The fact that there is seemingly an overlap that tends to happen when it comes to petitions against petitions against elections in Nigeria, and when winners are sworn in, and when these tribunals eventually make their decisions on these petitions.
I agree with you to some extent, but to be able to achieve that, that is a situation where the winner of an election will only be sworn in after determination of a petition challenging his victory. The only way it will work is for there to be an amendment of the Constitution to specifically state that in the Constitution that a person who has been declared winner of an election cannot be sworn in until the petition challenges his victory has been determined. But as it is right now, as Nigeria is with our body of laws as they are, there is no provision that prevents the swearing in of the winner of an election. So what that again will mean that is that for that to be taken into consideration, there will then be an amendment of the Constitution in such a way that the timeline within which INEC is now required to conduct election would have to come way before the 29th May inauguration. So that if you look at now for issues of election petitions, you know that the Court of First Instance in this particular instance, the Court of Appeal has 108 days to determine the petition. So we would have to put that into consideration so that when the lawmakers are making the law to say that the winner of an election can only be sworn in after the petition against his victory has been determined, it would then mean that there will be an amendment to ensure that INEC conducts election way before the May 29th date in such a way that the 180 days required for the determination of an election petition will also be taken into account, so that by the time the INEC conducts the election early enough, the 180 days at the Court of First Instance to determine the victory or otherwise of the election being challenged by the petitioners is determined. Then you also have to put into account the 60 days. You know that after the 180 days for the presidential election, there will then be whoever is agreed by the decision of the Court of Appeal, sitting as the Court of First Instance, will then have a right to appeal to the Supreme Court. And that appeal would have to, by law, must be concluded within 60 days of the filing of the appeal. You get, so what that again means is that not only will the Constitution be amended to make sure that the time within which INEC conducts election is way before the May 29th inaugural date, the timeline of the 180 days within which the petition is determined and the 60 days within which an appeal arising from the presidential petition is determined will all have to be put into consideration before that issue of a person who is declared to have won an election can only be sworn in after the challenge to his victory is concluded. Then be taken care of. That's the only way.
So, Mr. Trude, on this same issue, there seems to be a number of steps when we want to challenge, when people are willing to challenge the results of elections. But in terms of the impact on our democracy and governance, when we have some of these petitions decided after a different winner has been sworn in, and in some instances, we then have to swear in someone else, what do you think we're looking at in terms of how it impacts our democracy, how it impacts governance, how it impacts the citizenry, and how we think about the country that is Nigeria? Even though these timelines seem to be very long, 180 days, then you have 60 days. There's also a timeline for people to submit their petitions after the elections are held. So there are a number of steps, and it seems like, would it just really be worth it in the long run to make this change?
Yeah, absolutely. It's not ideal. It's not a democratic ideal at all. In fact, I would just go so far as saying that it is silly. If you look at the whole scenario, because if my memory serves me well, the scenario was different in 1999 when Obasanjo, in the election between Obasanjo and Olufalaye. If I remember correctly, it was decided before, that case was decided before the swearing-in date of Olusegun Obasanjo as president. That election. And so the whole thing was changed in the middle of the game. And again, we have seen even the declarations of the courts in removing a particular person who has held office about a year or 2 years. We give you an idea how silly, the whole arrangement is. I think also when the court was removing Ngige as the elected governor of Anambra, the court described him as an impostor, who was never governor of Anambra State for even 1 day. Because he did not have any legitimate authority to be governor of that state. But we all know, regardless of what the court said, whether it was an impostor, whether it should be assumed that he was never governor for even 1 day in Anambra State, the reality was that from a particular period in the life of Anambra State and in the life of the country, Chris Ngige was governor of Anambra State for a time. And so, you look at that, there's so much travesty in that situation because what happens when an incumbent gets to power. Incumbents can be so powerful and so influential. So when you allow somebody to get to power and he controls all the levers of government, he has so much power, and whether directly or indirectly, even over the exercise of justice, and the judiciary and the judges. And so you don't want a situation like that. You want everybody. We talk about equality before the law. So everybody must have equal opportunities. When they go to court, you don't have to give somebody overriding power and influence, over the system, so that he can manipulate that system for his own, personal advantage. And so I think that this is something that we in the civil society also have to agitate, also have to, agitate over to ensure that, like some of us and the media and everybody work together towards having, an electoral act. We have to look for a way to get the National Assembly to look at this provision and to realize that it is absolutely very wrong. You're talking about 180 days before, maybe to dispense with a particular, matter, and then another, 90 days, and all of those is absolutely unnecessary. Some of these things, if they are giving expedited action, can end within 4 months to 6 months. It is not impossible, and that is what we expect. But when you give such a long timeline, everybody will just generally relax, and then knowing that there's a long time. And meanwhile, the impostor, the person that will be named the impostor in the immediate future, if he's removed, continues to enjoy all the performances, of office before it's eventually removed. And when it's removed, he's not asked to pay back all of those state resources that he has used illegally and illegitimately. So it is absolutely wrong.
All right, as we start wrapping up, I need to bring in the Osun situation here. So let's look at that case, because it could have bearing on this situation if the challenges continued all the way up to the Supreme Court. So the case in Osun State is a peculiar one because it concerns overvoting and the use of BVAS to prove that. The judgment held that nothing in either Section 47 of the Electoral Act 2022 or Regulations 18 to 2023, or Regulations 18 to 23, I beg your pardon, of INEC's regulations made it mandatory for presiding officers in an election to transmit via BVAS and the number of accredited voters in each polling unit to the back-end server. So it just seems like it was left to the decision of the presiding officers. Mr. Ngweba, when we look at this, in terms of the ramifications of the Osun judgment and the potential it has to impact this case or these petitions, if they make their way to the Supreme Court, what do you think those ramifications could be?
Well, let me first start by putting out a caveat. I have not read a physical copy of that judgment, and I doubt whether the physical copy has actually come out. Because at least earlier in the morning, I had the information that the physical copy had not come out. So most of the things that I believe are being discussed now are based on what people who probably were involved then are saying. So I'd like to read the judgment first before I can say authoritatively what the Supreme Court said. But be that as it may, I think that the law really was basically just restated by the Supreme Court. That is Section 37 of the Electoral Act 2022, which talks about the manner of accreditation. So basically, it talks about the fact that accreditation will be done by the use of beavers. But most of the contentions that petitioners are talking about in some of these petitions have had to do with upload of results, using the beavers on the IREF. So, and what the Supreme Court has said is actually what the law is. There's nothing really. If you look at some of these sections that have been talked about by some of the petitioners, there is nothing in those sections, particularly the Electoral Act, that states that INEC must upload results mandatorily by way of electronic transmission. Right. So where you can find something very similar to that contention is in the INEC regulation. But then again, if you read further down, outside of I think paragraph 38 of that regulation, if you read further down, there are also provisions that talk about what the presiding officer can do where there is challenge or difficulty in uploading the results by electronic transmission. But the law is very clear. That regulation allows the presiding officer to go back to the manual way of collation, because all this really has to do with collation, right? And the truth of the matter is the electoral laws in Nigeria are the pyramid of the base of the pyramid of electoral laws in Nigeria are the forms EC8As at the polling unit levels. So if you are not contesting the correctness of the results at the polling unit level, but merely contesting that the results were not transmitted in accordance with the regulation, you really have not attacked the substance of the election.
Okay.
And mind you, if you look at Section 135 of the Electoral Act 2022, it talks about the fact that what the court looks at, or the tribunal looks at in the determination of an election petition, is whether there was substantial compliance with the principles
Of the law.
of the Electoral Act. Mm-hmm. So if the court is of the opinion that the election was conducted in accordance with the principles, that is the watchword there, the court is satisfied that the election was conducted in accordance with the principles of the Electoral Act, the court would be loath, the court would find it difficult to qualify any such election.
All right, so very quickly, I have a final question for the two of you, and I want to see if I can get this answer in just a minute because time is not with us. Because when we look at all of this, with the exception of the 2015 election when President Muhammadu Buhari defeated former President Goodluck Jonathan, every presidential election held in Nigeria since 1999 has ended up in some form of legal fireworks before some form of a court, tribunal, or whatever you want to call it. In terms of Nigeria's democracy and what that means, what do you think that points to when we end up in court almost every single time there is an election? Mr. Paul Mugwelba, to you quickly very much as we wrap things up. Just under a minute, please.
Right. I think it's good for our democracy. It's helping in shaping our electoral laws, because over time if you look at most of those election petitions, the Supreme Court has taken time to distill various principles that now guide our electoral jurisprudence. So if there were no such petitions, our electoral jurisprudence would not be as rich as it is at the moment. So I think that it's good for our democracy and encourage it, because the only other alternative would then be resource to violence. Nobody wants that. Nobody wants that.
Achike Chude, he says trying and testing the laws are good for our democracy. Do you agree with him when we have all elections, almost different levels, ending up in court?
When people say, let us sin so that grace may abound, I have a problem with it. Obviously, fine, perhaps our judiciary might grow from that, but our politicians have not grown. And that is just what the whole thing is all about, from 1999 till date. What they have done, what they did in 1999, 20-something years down the line, they are still doing it, and they are getting, and they're even worse, at it. So they have shown no respect for our democracy. They have shown no belief, in the democratic ideas. And so for them, political power is all that matters, nothing else. And that's why they keep on, causing so much disruption within the system. So they have learned nothing, they have forgotten nothing. And I think that it is time for them to go on. And it is also time for the Nigerian people to also be more politically conscious, so that whatever way they can, try to checkmate some of this perfidious behavior on the part of our politicians, that they need to do that, because ultimately, if everything goes south in our country, all of us will go with it. So that's just what we do. We can't keep on doing the same thing so that grace may abound, especially if it is evil that we're doing.
All right, so we'll leave the conversation at that. There are some more sittings tomorrow and, of course, into next week as well. We'll keep the conversation very much alive here. Achike Chude, Public Affairs Analyst, and Paul Ingbeoba, Legal Practitioner.
It's been a pleasure.
Thank you so much for joining me tonight.
Thank you.